Real estate contract. Let's get started. Which of these characteristics does not describe a fee simple estate? Is it A, freely transferable? Or B, freely inheritable? Could it be C, definite duration? Or lastly D, unlimited duration? The correct answer is C. Here is why. A fee simple estate is the most complete form of ownership. It is freely transferable, A, freely inheritable, B, and of unlimited duration, D, it lasts forever. Therefore, having a definite duration, C, is the characteristic that does not describe a fee simple estate, that describes a leasehold. Next question. A man dies without leaving a valid will. He is said to have died. Is it A, intestate? Or B, in fee simple defeasible? Could it be C, probate? Or lastly D, via devise? The correct answer is A. Here is why. To die intestate, A, means to die without a valid will. Probate, C, is the court-supervised process of administering an estate. Devise, D, is a gift of real property by will. Fee simple defeasible, B, is a type of estate, not a condition of death. Next question. A woman possesses a fee simple estate. Which of the following can she not do to the property? Is it A, sell it? Or B, subdivide it? Could it be C, use it contrary to zoning regulations? Or lastly D, will it? The correct answer is C. Here is why. A fee simple owner has nearly unlimited rights, but these rights are always subject to the government's police power. Zoning regulations are an exercise of police power. Therefore, the owner cannot legally use the property in a way that violates zoning regulations. C. She can sell, A, subdivide, if compliant with subdivision regulations, B, and will, D, the property. Next question. Which of the following can the grantor of a life estate not do? Is it A, grant title using an assumed name? Or B, receive title upon the death of the life tenant? Could it be C, take back fee title at any time? Or lastly D, create a life estate for the life of more than one person? The correct answer is C. Here is why. The grantor of a life estate creates a vested interest in the life tenant. The grantor cannot arbitrarily take back the fee title, C, at any time. They only hold a future interest, a reversion, that becomes possessory automatically upon the termination of the life estate, typically at the life tenant's death. They can use an assumed name if properly executed. A, they will receive title upon the life tenant's death if they retained a reversion. B, and they can create a life estate measured by multiple lives. D. Next question. A licensee is concerned about a construction project going on next to a property she is selling. Where would she be best advised to go to clarify any question about an encroachment? Is it A, city attorney? Or B, planning department? Could it be C, licensed surveyor? Or lastly D, tax office records? The correct answer is C. Here is why. An encroachment is a physical intrusion of a structure or improvement from one property onto another. The definitive way to determine the exact location of property boundaries and identify potential encroachments is to have a licensed surveyor, C, perform a survey and prepare a surveyor's plat. The planning department, B, deals with zoning and land use, not physical boundaries. The tax office, D, has records for assessment, not precise boundary lines. The city attorney, A, provides legal opinions, not survey measurements. Next question. An owner sold a parcel of real estate to a buyer with the stipulation that the buyer was not allowed to sell alcohol from the premises. The buyer sold the property 10 years later to a buyer who converted the building into a convenience store that sold beer. Should the owner or owner's heirs claim a right of re-entry, what would be the basis for the lawsuit? Is it A, violation of a covenant? Or B, violation of a condition subsequent? Could it be C, violation of a condition precedent? Or lastly, D, violation of the statute of frauds? The correct answer is B. Here is why. This scenario describes a defeasible fee estate with a condition subsequent. The original grant, not allowed to sell alcohol, created a fee simple subject to a condition subsequent. If the condition is violated, alcohol is sold. It gives the grantor or their heirs a right of reentry to reclaim the property. Therefore, the lawsuit would be based on the violation of a condition subsequent, B. A covenant, A, would typically result in a suit for damages, not a reversion of title. A condition precedent, C, must be fulfilled before an estate is created. That's it for today. How many did you score? Let me know in the comments. Please like and subscribe, and tell me what topic I should cover next. Bye.